January 31, 2018, GR number 207613. The case of Mr. Reynan Minsola, petitioner versus New City Builders Incorporation and Engineer Arnel Fajardo, respondent. This case was typical example of common labor issue that happened in the Philippines during past 2 decades, in which tenure of labor was not secure anymore as contractual basis was came into law. Moreover, the complaint root cause when the petitioner had worked in 2 consecutive project-based contracts to the respondent project, which was the Avida Tower 3, wherein presumed by the petitioner that he had rights to claim as regular employees when he worked in different phases of the project with few days of transition period apart from each phase, and his duration of employment was more than a year. Thus, he performed labor position in the structural phase and hired as mason for architectural phase of the project. Moreover, the respondent were not able to complete all the necessary formalities as appointment for the second phase, and it was not completed by the petitioner as he stopped reporting after he was instructed to sign and update his employment record. More so, it was proven that the respondent paid salary to the petitioner was lower than in minimum wages during that time. However, the petitioner Minsola filed a complaint for illegal dismissal, underpayment of salary, non-payment of 13-month pay, separation pay, and refund of cash bond. In his position paper, Minsola claimed that he was a regular employee of New City as he rendered work for more than 1 year, and that his work as laborer or mason is necessary and desirable to the firm's business. He claimed that he was constructively dismissed by New City. However, the petitioner Minsola filed a complaint for illegal dismissal, underpayment of salary, non-payment of 13-month pay, separation pay, and refund of cash bond. In his position paper, Minsola claimed that he was a regular employee of New City as he rendered work for more than 1 year, and that his work as laborer or mason is necessary and desirable to firm's business. He claimed that he was constructively dismissed by New City. Ruling of the Labor Arbiter. On October 8, 2010, the Labor Arbiter rendered a decision dismissing the complaint for illegal dismissal. The Labor Arbiter found that Minsola was a project employee who was hired for a specific project by New City. The fact that Minsola worked for more than 1 year did not convert his employment status to regular. The Labor Arbiter stressed that the second paragraph of Article 280, which refers to the regularization of an employee who renders service for more than a year, pertains to casual employees. Likewise, the Labor Arbiter opined that Minsola was not terminated from work. The Labor Arbiter noted that the records are bereft of any proof or evidence showing that Minsola was actually terminated from work. Rather, it was actually Minsola who suddenly stopped reporting after he was instructed to sign and update his employment record. Thus, the Labor Arbiter ordered Minsola's reinstatement until the completion of the project. However, for monetary claims, the Labor Arbiter awarded 2,652 pesos as 13-month pay differential. Also, the complaint for illegal dismissal is dismissed for lack of merit. However, respondent New City Builders Incorporation is ordered to pay complainant his 13-month pay differential in the amount of 2,652 pesos. Ruling of the NLRC or National Labor Relations Commission. On April 29, 2011, the NLRC rendered a decision reversing the LA's ruling. The NLRC found that Minsola was a regular employee and was constructively dismissed when he was made to sign a project employment contract. NLRC concluded that Minsola became a regular employee when his services were continued beyond the original term of his project employment, without the benefit of a new contract fixing the duration of his employment. Likewise, the NLRC noted that Minsola's job as a laborer or mason was necessary and desirable to the usual business of New City. Ruling of the Court of Appeal. On December 21, 2012, the CA reversed the NLRC's decision. The CA ruled that Minsola was a project employee. The CA reasoned that Minsola was hired for specific phases in Avida 3. He was originally hired as a laborer for the structural phase of the Avida 3. Upon the completion of the structural phase, he was rehired in different capacity as mason for the architectural phase of Avida 3 construction. The CA observed that Minsola's tenure as a laborer was covered by an employment contract, which clearly provided that he was hired to work for a certain phase in the construction of Avida 3, and that his term of employment will not extend beyond the completion of the same project. Likewise, the CA observed that the records are bereft of any proof showing that Minsola was constructively dismissed by New City. The issues, the petition is partly impressed with merit. As a general rule, the court is not a trier of facts and does not normally embark in the evaluation of evidence adduced before the lower tribunals. However, this rule allows for exemptions. One of these is when the findings of fact of the quasi-judicial agency concerned are conflicting or contradictory with those of the CA. When there is a variance in the factual findings, it is incumbent upon the court to re-examine the facts once again. Minsola is a project employee of New City. Essentially, the Labor Code classifies four kinds of employees, namely regular employees or those who have been engaged to perform activities which are usually necessary or desirable in the usual trade of the employer. Number 2, project employees or those whose employment has been fixed for a specific project or undertaking, the incompletion or termination of which has been determined at the time of the employee's engagement. Seasonal employees are those who perform services which are seasonal in nature and whose employment lasts during the duration of the season. Casual employees are those who are not regular, project, or seasonal employees. Jurisprudence was added a fifth kind, fixed-term employees, or those hired only for a definite period of time. Focusing on the first two kinds of employment, Article 294 of the Labor Code, as amended, distinguishes regular from project-based employment as follows. In the case at bar, Minsola was hired by New City Builders to perform work for two different phases in the construction of Avida 3. The records show that he was hired as a laborer for the structural phase of the Avida 3 from December 16, 2008 until August 24, 2009. Upon the completion of the structural phase, he was again employed on August 25, 2009 by New City, this time for the architectural phase of the same project. There is no quibbling that Minsola was adequately informed of his employment status at the time of his engagement. This is clearly substantiated by the latter's employment contract stating that he was hired as a project employee, his employment was for the indicated starting dates therein, and will end on the completion of the project. The said contract sufficiently apprised Minsola that his security of tenure with New City would only last as long as a specific phase for which he was assigned. Notwithstanding the notice regarding the term of his employment, Minsola avers that his continuous work as a laborer and mason, coupled with the fact that he performed tasks that are necessary and vital to New City's business, made him a regular employment of the latter. The court is not persuaded. Accordingly, it is not uncommon for a construction firm to hire project employees to perform work necessary and vital for its business. Suffice it to say, in William Oy Construction Corporation, the court acknowledged the unique characteristic of the construction industry and emphasized that the laborer's performance of work that is necessary and vital to the employee's construction business and the former's repeated hiring do not automatically lead to regularization. Accordingly, it is all too apparent that the employee's length of service and repeated rehiring constitute unfair yardstick for determining regular employment in the construction industry. Thus, Minsola's rendition of more than 1 year of service and his repeated rehire are not badges of regularization. Minsola was not constructively dismissed by New City. Minsola contends that New City constructively dismissed him when he was allegedly forced to sign an employment contract, termination report, and other documents. The court is not persuaded. In the case at bar, Minsola failed to avert to any particular act showing that he was actually dismissed or terminated from his employment. Neither did he allege that his continued employment with New City was rendered impossible, unreasonable, or unlikely, nor was he demoted, nor made to suffer from any act of discrimination or disdain. Neither was there any single allegation that he was prevented or barred from returning to work. On the contrary, it was actually Minsola who stormed out of New City's office and refused to report to work. It cannot be gainsaid that there is no illegal dismissal to speak of where the employee was not notified that he had been dismissed from employment, nor was he prevented from returning to his work. Minsola is entitled to salary differential, 13-month pay differential, service incentive leave differential, holiday pay, and attorney's fees. Notably, in determining the employee's entitlement to monetary claims, the burden of proof is shifted from the employer or the employee depending on the monetary claim sought. In the instant case, the records show that Minsola was given a daily wage of 260 pesos, as shown by his employment contract dated December 16, 2008. It must be noted that this amount falls below the prevailing minimum wage of 382, mandated by Wage Order Number NCR 15 effective August 28, 2008 to June 30, 2010. Clearly, Minsola is entitled to salary differential from December 16, 2008 until January 19, 2010 in the amount of 41,616.64. Likewise, Minsola is entitled to service incentive leave pay differential in the amount of 310 pesos, as the amount of service incentive leave pay he received on December 19, 2009 was only 1,600 pesos instead of 1,900 pesos. He is also entitled to a 13-month pay differential of 2,652 pesos. Moreover, Minsola is entitled to a holiday pay of 5,340 pesos for 2 unworked legal holidays in December 2008, 11 unworked legal holidays in 2009, and 1 legal holiday in January 2010, as New City failed to present the payrolls that would show that Minsola's salary was inclusive of holiday pay. On the other hand, Minsola's claims for premium pay for holiday and rest day, as well as night shift differential pay, are denied for lack of factual basis. And Minsola failed to specify the dates when he worked during special days or rest days for between 10 p.m. or 6 a.m. Finally, Minsola should likewise be awarded attorney's fees, as the instant case includes a claim for lawfully withheld wages. For my personal note, it is very important to ensure that during hiring stage, the employer must ensure that the employee understood his contract. Also, the employer must not allow to onboard any employees without completing all HR formalities to protect both parties' interests in the future. Having said, both parties have deviation, as I have observed that the petitioner intentionally did not sign his new appointment, unable to have a reason to claim regular status. However, the respondent is not paying the correct wages rate during that time.